In this video, I want to discuss with you something that I come across very regularly, and that is the question of a conflict of story or a conflict of narratives or different versions of events put forward by different people in a dispute situation. Let me give you an example and you'll know exactly what I mean. Say you have a grievance in the workplace and you raise a grievance about some other employee, perhaps a colleague, perhaps a manager, supervisor. You might raise a grievance, you might raise a complaint in accordance with the dignity at work policy or procedure. You might claim that you're being harassed, sexually harassed, bullied, discriminated against, whatever. A lot of times there is no written documentary evidence about what it is you claim has occurred, and to support your case, to support your claim that you were, for example, bullied, or for example, that somebody dealt with you inappropriately. What you may have is no written evidence, and what you may have then is two conflicting versions of events. There's going to be your version of events, and there's going to be the other party's version of events, of what occurred. And there's going to be a difficulty there, clearly, for the decision maker. Now, the decision maker may well be somebody in HR, it may well be somebody further up the hierarchy in your organization, it may be the owner, it may be even at the WRC where you bring a complaint to the WRC, the Workplace Relations Commission. It could even be in court. But if you're facing a situation where there is just conflicting versions of events, conflicting narratives, in other words, he said, she said, there's obviously going to be a difficulty for the third party who has to make a decision. But the way they're going to make that decision is they're going to look at all of the surrounding circumstances and they're basically going to find or decide which is the most likely version of events. So they're faced with two different stories, one from you, one from the other party who is defending themselves, saying, no, I didn't bully him or her. And then the decision maker is going to have to make a decision based on what is the most likely version of events, what's most likely to have occurred. And that's it. That's really it. So if you have a grievance, if you have a bullying complaint, a sexual harassment complaint, a discrimination complaint, and there's an absence of third-party witnesses, there's an absence of any written documentation to support your claim, if it comes down to essentially a swearing match between you and the other party, then you must consider the third party who is making a decision. They will just decide on the basis of probability. They'll decide on the basis of which is the most likely story, which is the most likely version of events. And sometimes the third party, the decision maker, is not able to arrive at a finding of fact. In other words, they might just say there's a conflict of evidence here, a conflict of narrative, and I can't make up my mind, or I can't find on one side or the other. On the other hand, in court or at the WRC or anywhere else, I have often seen cases where the decision maker, either the judge or the Workplace Relations Commission adjudicator, says there was a conflict of evidence and I preferred the evidence of A or B. In other words, they're not saying that the other party was lying, they're not saying that they were untruthful, but they were saying there was simply a conflict of evidence, a conflict of story, a conflict as to how or what happened, and essentially the adjudicator then, or a judge, has to decide on the balance of probabilities what happened. And as I say, they do that in a way which doesn't call one party or other a liar or an utterer of untruths. They simply say there was a conflict of evidence and I prefer the evidence of Mary or I prefer the evidence of John. That's something that's important and worth bearing in mind, that whole question of conflict of story, a different version of events, essentially a swearing match sometimes. Because if you have a grievance in the workplace and you have a blow up with a colleague and you put in a complaint of some description, remember, just step outside your complaint if you can for a few minutes, put yourself in the feet and the seat, as it were, of the decision maker and see what they're faced with. They may be just faced with two completely different versions of events, and it may or may not be upheld in your favour. So that's something that you need to bear in mind. It is not necessarily a reflection on you or your honesty, but you should bear it in mind if you bring a grievance or an allegation of bullying or anything else, in the absence of written documentation, in the absence of emails or maybe other colleagues witnessing inappropriate behaviour that you've suffered. In that absence, then you may be just facing a conflict of evidence, a different version of events, and you may be facing a decision maker, the person who has to deciding that I prefer his evidence or I prefer her story. And that's essentially it. It's not a court of law. It's not beyond the reason or beyond the balance or beyond the reasonable doubt like the standard of proof required in a criminal case. It is which is the most plausible version of events where there's a conflict. I hope you find this video useful. You should probably bear it in mind when you bring a grievance, etc., if you don't have sufficient evidence or if it's simply your word against somebody else's. Because remember, I would always put myself in the shoes of the third party and try to anticipate what they might see and what they might decide. And they may be faced with a very, very difficult situation, a completely diametrically opposed version of events from both parties, in which case it may well be that they find it very difficult to make a decision or a fair decision. I hope you find this video useful. If you do, you might give it a thumbs up down below. And thank you for all your shares, your comments, your likes on my YouTube channel.